Join me today as we talk about Joinder. 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 Make sure to stay tuned until the end of the video, where I will attach, like always, a chart that details everything that I've talked about in the video today that I prepared while studying for the bar exam, and hopefully it can help you visualize all these complex topics and see what the big picture is in the whole world of civil procedure and joinder. Today's explanation will be broken off into four different parts. From the perspective of the plaintiff, the perspective of the defendant, the perspective of a non-party, and then the perspective of groups. I will go through each of them and talk about the different implications of each. For a plaintiff, you have to, with plaintiff joinder questions, you have to ask yourself, is this claim part of the same transaction or occurrence, and does it raise a common question? Then you have to ask yourself, is this party necessary? What does necessary mean? It means that the other parties cannot be granted complete relief if this party is not part of the litigation, of the trial, of the whole shebang. I'll try to put it in this way. Think about cereal. What are the main components of cereal? Milk and the cereal, whether it be cornflakes. Let's say it's cornflakes. So it's cornflakes plus milk equals cereal. What if you only have cornflakes? Can you have a satisfactory bowl of cereal? No. Milk is necessary. So you have to ask yourself, is this party the milk of the cereal? If it's not necessary. And if it is, you best believe you have to include it, because you cannot eat the bowl of cereal without milk. You cannot grant complete relief unless you have the necessary party. Now that you've determined that the party is necessary, you have to ask, is it feasible to join this party into the case? To look at that, you have to make sure that the court has personal jurisdiction over this party. And what is personal jurisdiction again? That the court must at least have minimum contacts with the person must have minimum contacts with the forum state. And if this is a diversity case, which deals with subject matter jurisdiction, this additional party, this additional plaintiff will not break diversity, because if the necessary party is brought in and breaks diversity, then the case gets thrown out. It can't be heard in court. Now, what happens? Let's just say, the reality is that not every single case that has a necessary party doesn't end up joining them. What happens if the necessary party is not joined? Well, it's not the end of the world, even though it might feel like it for some people, but either the case gets dismissed or the court just proceeds without it. So if you're necessary and the court has personal jurisdiction over you and you're not breaking the subject matter jurisdiction, then you are good to go. If not, you have to think outside the box. With the defendant joining a defendant party, there's 3 different avenues that this can happen. It's either through a counterclaim, a cross-claim, or an interpleader. I'm going to tackle all 3 of them right now, but I'm going to repeat it once more. The defendant can be joined either, counterclaim, cross-claim, or interpleader. A counterclaim is when the defendant brings a claim against the plaintiff. It could either be compulsory or permissive. Compulsory means that if you don't bring it up, you lose it. Permissive, and it's from the same transaction or occurrence. If it's a permissive counterclaim, it's not part of the same transaction or occurrence. You can bring it up, but you don't lose the opportunity to raise it. So how does that play in the real world? Suppose I am the defendant and I'm driving down the street and I'm not paying attention. I'm texting, which is not a good idea. Don't text and drive. Texting, I hit the car in front of me. plaintiff. So what happens? I damage the car. But also, the plaintiff breaks his leg. So what happens? The plaintiff sues me in civil court and for the damages of the car. That's the claim. Wait. I'm not making any sense. Give me 1 second. Okay, I'm back. So I was texting and driving. I crashed into the plaintiff. The car was totaled, but the plaintiff didn't break his leg. Instead, he got out of the car, confronted me, started fighting me, and he kicked me and broke my leg. So my leg is broken. So what happens? The plaintiff sues me for damaging the car, for crashing into his car, rightfully so. But then I come with a compulsory counterclaim because he broke my leg as part of the same transaction or occurrence. So I am suing the plaintiff for breaking my leg. Does that make sense? Let me draw it out. Give me 1 second. Now I'm going to present to you my whiteboard with a ring light. Okay, so here we have plaintiff versus defendant. Let me see if I can... No, this way. Well, anyways. The plaintiff sues the defendant for the damage to the car. And then the defendant comes back and counterclaims. So defendant versus the plaintiff. As you can see, the arrows going from defendant to plaintiff. And it says the broken leg. This is a compulsory counterclaim because the issue of the broken leg arose from the same transaction or occurrence as the damage to the car. The broken leg would not have happened had I not crashed into that man's car. Now, it would be permissive if I sued the plaintiff for a breach of contract. Suppose he had contracted me to paint his house, or I had contracted him to paint my house, and it didn't happen. The breach of contract has nothing to do with this accident, which would be the transaction or occurrence. Since it's not the same transaction or occurrence, that would be permissive. That means that I could then sue the plaintiff on a completely different matter at a later date, that breach of contract, because it is not related. One more time. Compulsory counterclaim is when the counterclaim arises from the same transaction or occurrence. Here it was the car crash. After the car crash, plaintiff was mad, came over, beat me up, broke my leg. So that the broken leg was incident to the same transaction or occurrence, to the car accident. If I have a claim against the plaintiff for a breach of contract, this had nothing to do with the car accident, because it's not like we were talking on the phone while we were driving and we were coming up with the terms of the contract. That wouldn't even be enforceable because there is nothing signed. Anyways, I hope you can now see the distinction between compulsory and permissive counterclaims. A cross-claim is when a defendant has another claim against another defendant named in the same suit that arises from the same transaction or occurrence. I know what you're thinking. Mind blown. What does that mean? This is what it looks like drawn. So we have a plaintiff versus two defendants. And then defendant 1 has a case against defendant 2. Let's use the same example as before. I'm driving, texting, crash into plaintiff, but also my friend, defendant Daniel, D for defendant, also crashes into plaintiff. So it's a 3-car collision, which is pretty common in the driving world. So plaintiff has a claim against me, defendant 1, against me, defendant 1, and Daniel, defendant 2, because we both contributed to the accident. Now, let's suppose that Daniel gets out of his car and Daniel decides to beat me up because he's having a bad day and he's not happy that now this has happened. He was running late for a meeting and he breaks my leg. So then I decide to sue Daniel as a cross-claim because he's a named defendant, but the issue also arises from the same transaction or occurrence. So Plaintiff sues me and Daniel because it was a 3-car collision course. Then I sue Daniel, which you can see on this side, that Daniel broke my leg, and I'm mad. Of course I'm mad. I have a broken leg. So as you can see, all the characters are now fitting into this narrative. Now that we've covered counterclaim and cross-claim in the world of the defendant, we're now going to the third one, which is impleader. This is when the defendant says, it wasn't my fault, it's someone else's fault, and adds that other person into the narrative that is this litigation. So what does that look like? This looks like plaintiff sues defendant, and then defendant decides to say that the impleader is actually the person who is responsible. Using the same example as the car crash. I crashed into plaintiff, but let's say that somebody else was driving my car. So while it was my car, the person driving was my friend. I is for Isabela. So Isabela and I were going to go to the beach. It was a beautiful Saturday day. The sun was out and it was going to be great. We weren't paying attention. She wasn't paying attention, but we were driving in my car. So what happens when the accident occurs and all the police reports are written up? It's as if, because it's my car, I'm the one that is put on the hook. But then once I get sued, I'm like, wait a minute. I was just the passenger in the car. I'm not the one that should be held liable for this. So I bring in Isabela into the suit. Now, there's 2 ways that you can implead. You can do indemnity, which is transfer full liability to another party, or contribution, which is part liability. Now, am I feeling generous? I guess you could say in this case, it would be contribution because I was also in the car. I could have told Isabela, hey, get off your phone. That text can wait until the red light or until we arrive at the beach. But I didn't. But anyway, that's a different conversation between me and my friend. But as you can see, the impleader was not a defendant, but now could be the defendant because of either partial or total liability for, in this scenario, the accident. We are moving forward. Now that we've covered the plaintiff, those consequences, the defendant and those consequences, now we're entering the world of the non-parties. A non-party is someone who is neither the plaintiff nor the defendant. So how does a non-party come into play? Well, a non-party can intervene, can insert themselves into the narrative, either as a plaintiff or defendant. What? How can they join themselves if they weren't named in the party? Well, there's 2 ways that a non-party can intervene. The non-party can either intervene as a matter of right or permissive intervention. So matter of right is that it emerges from the same transaction or occurrence and has a common question, or permissive intervention is only when there's like a common question. So when would it be of right? Using the same example of the car crash, of me crashing into the plaintiff, suppose we say that there was also like a third party in the collision, but it was just a scratch. So the plaintiff did not join that other party because either didn't know or didn't feel like it. So this person can intervene and be like, wait a minute, defendant like skirted my car. I should be able to get something. So then the non-party would file some documents in the court and ask to be part of this litigation because it's from the same transaction or occurrence, it's the same accident, and it's a common question whether or not the defendant is liable. That would be the question of the case. If it was permissive, it could be maybe like a bystander was watching and what could have happened. It's all up in the air. But just basically know that a non-party can intervene if it's part of the same transaction or occurrence and there's a common question that needs to be answered. Now we're moving on to the last section, groups. in simple terms, can be described as those class action suits. I know you've heard about them on the news, a headline, and it's always when there's a common injury that has affected a grand multitude of people. It would not be wise to be able, or it just wouldn't be effective to try all these cases separately if it's arising from the same issue. So what happens is that the court consolidates them as a class action. Someone's appointed as a representative, and then everyone, if there's a settlement or if there's a result, everyone gets paid out from that bucket. You have the choice not to be included in the class action. No one's forcing you, but the class action is basically a collective of similar cases. So instead of taking the time to try each case and then each judge could have a different ruling, that would bring out a lot of inconsistency. So to maintain a level of consistency, class actions are used for judicial economy, and also it eases out, and people are generally happy, I guess, with the results of the class action suits. Anyways, that's all for now. Thanks for watching. Good luck studying. Studying for the bar exam sucks. I've been there, done that. And as promised, here I will now include a screenshot or a snapshot of my chart, and hopefully it'll help you study. And you've got this. Believe in yourself. You've put yourself through law school. You can do this.